Making a foreign will. How should you manage your overseas assets? A large number of people in the UK own property abroad, and, in many cases, the succession laws of the country in which the property is located could govern the disposition of that property on the owner's death. For that reason, it is often a good idea to have a foreign will to deal with any significant overseas assets that you might own. Different laws, different outcomes. Sometimes the inheritance laws in a foreign country will operate much differently to UK law. In the case of property, for example, some countries' laws state that local law governs the disposition of the property on the death of the owner, whereas others state that the law of the owner's country of nationality applies. So, without a will that is governed by local law, there could be confusion as to which law applies to the property, and the different laws might lead to very different outcomes. It is also important to recognize that in some countries, there are inheritance laws that override the intentions of the deceased, requiring that a certain part of the deceased's estate be left to certain specified relatives. So, you may need a local will, as well as some additional planning, if you want to circumvent the effect of such laws and leave the property to the person or people that you select. Practical hurdles. If you own property abroad and die with an English will, but without a will that is governed by the local law, your heirs could face a number of practical hurdles that could result in delays in their obtaining title to the property as well as additional costs. For example, if the country in question is not an English-speaking country, your executor or heirs may need to have documents translated for presentation to the relevant officials in that country. In addition, there may be legalization requirements, which can be time-consuming and expensive. Your heirs may well have to hire a local lawyer to assist them, although they may need a local lawyer in any event, even if you have made a local will. Potential for mishaps. In a recent case, there was considerable confusion for the heirs of a man who died with two wills, one made in England and the other in a foreign country where he owned property. The difficulty arose because his foreign will, which was only intended to apply to the assets he owned in the foreign country, specified that it revoked all prior wills. Although the revoke all prior wills clause is standard form language in a will, in that case it was not what the testator intended to do. He wanted to have two wills that worked in parallel, one for the bulk of his estate in the UK and one for his foreign assets. Fortunately, it seems that the court accepted that the man had not intended to revoke his English will, but the case, and the fact that it went to court, illustrates the potential for mishaps. Possible relief. You should note that the estate of a person who is domiciled in the UK for purposes of inheritance tax (IHT) is liable to pay IHT on its worldwide assets, which, of course, would include a property in a foreign country. There may, however, be some relief available under a double taxation treaty with the country in which the property is located, particularly if there is also IHT liability in that country. The question of domicile can be a complicated one. A British citizen who intends to rely on non-domiciled status should obtain professional advice in relation to the issue, as there could be significant tax consequences if HMRC does not accept the claim to non-domiciled status. Want to review your situation? To arrange an appointment or to discuss any concerns that you may have in relation to making appropriate protection for you, your loved ones and your estate, please contact us. We look forward to hearing from you. Smith Equity and Trusts. 0207 193 0946